I've been doing this for, 20 years now. And it's one of those films that you really feel how special it is. That speaks to Colleen's work. Like with the source material that we had a book that there was a story and emotional journey that resonated with so many people. So it was our responsibility not to screw it up. Yeah, it was just such a beautiful experience, and I couldn't be more proud of it. I'm just really excited for people to see it.
Breaking news out of the Southern District of New York. Judge Lewis Lyman has just issued a ruling that could completely reshape the ongoing legal battle involving Blake Lively, Ryan Reynolds, their company Van Zandt Inc., and former publicist Stephanie Jones. This new decision comes from the counterclaims filed by Jen Abel against Stephanie Jones. And while several federal hacking claims were dismissed, 2 major allegations have survived. And these could have the most serious implications yet. At the heart of the case is Liefeld, who drew Lady Pool.
I love Rob.
He's cool,
Isn't
right?
he great?
Yeah. He, I had no idea, but in 2010, he drew Lady Deadpool. And at the same time, I was cast in the Green Lantern with my now husband, who is not my husband then.
Okay.
The timeline, I know, it gets a little like you need a conspiracy yarn to track it. But basically, there was
one crucial question. How did Jen Abel's phone data allegedly end up in the hands of Blake Lively, and was it accessed without authorization? Abel claims her personal data was taken and used without her consent, later becoming part of the materials that fueled Blake Lively's lawsuit against Justin Baldoni and others. Judge Lyman dismissed some federal claims, including those under the Computer Fraud and Abuse Act, the Stored Communications Act, and the Wiretap Act, due to technical pleading issues. However, 2 powerful claims remain: violations of California Penal Code Section 502, California's computer crime law, and conversion, a civil claim often referred to as civil theft. Under Section 502, it's illegal to knowingly and without permission access another person's data. The judge found that Abel had adequately alleged that Jones knowingly accessed her phone and iCloud account without permission. Abel says she gave her passcode only to help transfer her phone number, but that Jones and her team retained access to her iCloud afterward, bypassing password protections and accessing private content. The court accepted Abel's allegations as plausible, especially since she was using her personal phone for work, and there were no clear policies allowing Jones's firm to monitor her data. Abel claims she had every reason to believe her private accounts would remain confidential, and that she would never have handed over her device had she known otherwise. The conversion claim adds another layer. Abel alleges she was locked out of her phone, her 2-factor authentication, and her accounts, forcing her to spend time and money regaining control. Together, these claims suggest unauthorized access to her data and real-world harm resulting from it. Judge Lyman also noted that because the alleged acts occurred in California, California law applies, a detail that could pose future complications for Blake Lively's legal team, since some of her own claims rely on California law even though they may have occurred elsewhere. The judge's ruling allows Abel's case to move forward into discovery and potentially to trial, which means Lively's side could soon face tough questions about how that data allegedly moved from Abel's phone to Stephanie Jones to Van Zandt Inc., and ultimately into Blake Lively's court filings. As for the dismissed federal claims, the judge gave Abel permission to amend her complaint and provide more specific evidence, particularly regarding whether certain screenshots or files were accessed directly from iCloud rather than just from the phone itself. If she can make that connection, it could significantly strengthen her case and increase the potential legal exposure for those involved. In short, this ruling doesn't end the battle, it escalates it. The surviving claims strike at the core of the controversy and could open the door to serious consequences for multiple parties, including Blake Lively's legal team. Judge Lewis Lyman's ruling from the Southern District of New York has set the stage for a major showdown in the ongoing legal battle involving Blake Lively, Ryan Reynolds, Van Zandt Inc., and former publicist Stephanie Jones. The decision outlines what Jen Abel must do to strengthen her case and explains how this ruling could create serious legal trouble for Jones and potentially ripple back toward Blake Lively's team. To move her case forward, Abel must now provide concrete proof. The judge made it clear that she needs to show exactly what data was accessed, what files, messages, or screenshots came from her iCloud, her Gmail, or directly from her phone. The Stored Communications Act only applies if the data was taken from storage, like iCloud or Gmail, not if it was pulled directly from the phone. Similarly, for her Wiretap Act claim to stand, Abel must prove that her communications were intercepted in real time, meaning they were monitored or captured live as they came through iCloud, not accessed later. If she can show evidence of that live interception, the claim could be reinstated. The invasion of privacy claim also needs more detail. The judge ruled that Abel's original filing didn't describe why the intrusion was highly offensive or how it caused emotional or reputational harm. To fix this, Abel will need to show the emotional toll of having her private data accessed and exposed, describing in detail the humiliation, distress, or sleeplessness it caused. There's also the false light issue. Abel alleges that Jones's team altered or selectively edited her private messages to make her look bad and support a false narrative. However, the judge noted that the current filing doesn't include enough examples or direct proof. Abel will now have to identify which messages were changed, how they were presented publicly, and how that misled others about her. As for her claims of emotional distress, both the intentional and negligent infliction claims were too vague. Abel must describe specifically how being locked out of her phone and accounts, losing access to her data, and seeing her private content used against her caused serious anxiety, emotional pain, and reputational damage. The promissory fraud claim also needs more clarity. Abel alleges that Jones promised to port her phone number back to her, and that she provided her passcode only for that purpose. But the judge said she needs to specify who made the promise, when it was made, how she relied on it, and how it led to harm. In summary, Abel's claims aren't dead. She has the opportunity to amend her complaint and strengthen them with more evidence and detailed examples. What this means for Stephanie Jones. Two of Abel's most serious claims, California Penal Code Section 502, computer data access, and conversion, civil theft, are moving forward. These directly implicate Stephanie Jones, who was once Justin Baldoni's publicist. Section 502 claims that Jones illegally accessed Abel's phone and data, while conversion covers the harm caused by locking Abel out of her accounts and phone number. Because Section 502 also carries criminal implications in California, this could get dangerous for Jones. Evidence uncovered during civil discovery, such as emails, messages, or digital trails, could attract the attention of state prosecutors if criminal conduct is found. The ripple effect for Blake Lively and Van Zandt Inc. If Abel proves that Jones accessed her data and that it was later funneled through Van Zandt, the company tied to Blake and Ryan, the consequences could be massive. Abel's claim is that the stolen data was used to create the foundation for Blake Lively's lawsuit against Justin Baldoni, Abel, and others. According to Abel, the timeline starts in August 2021, when a phone call revealed that her private messages had been seen and that legal action was coming. She alleges that Jones passed the data to Van Zandt, which then used it to file a sham lawsuit designed to make the stolen material appear legitimate. Judge Lyman has already allowed Abel to begin obtaining Van Zandt's internal emails and communications, which could expose whether Jones sent files directly to Van Zandt, whether Van Zandt's lawyers knew the data was obtained unlawfully, and whether Blake Lively's team built their case using that material. If the evidence shows that chain, Abel's phone, Jones, Van Zandt, Blake's filings, it could mean serious consequences. The court could exclude key evidence from Blake's lawsuit. Abel could pursue punitive damages against Jones under Section 502. The judge could impose sanctions if it's proven that Blake's side knowingly used unlawfully obtained data. The ruling keeps the core claims alive, meaning Abel can continue digging for evidence. Her amended complaint is due October 31st, after which the court will likely hear another motion to dismiss, but the judge has already made it clear that Section 502 and conversion will remain in place. In short, this case isn't slowing down. It's about to get much more intense, and the stakes for Stephanie Jones, Van Zandt Inc., and Blake Lively have never been higher. All right, besties, buckle up because the latest update in the Blake Lively versus Justin Baldoni legal saga has completely flipped everything we thought we knew about this case, and it's honestly wild to see how deep the digital evidence trail might go. What began as a simple dispute has now turned into a tangled web of privacy, data access, and possible misuse of subpoenas, and the judge's latest order has left both sides scrambling to figure out what's next. So here's what's happening. Jennifer Abel, the woman at the center of the controversy, alleged that Stephanie Jones, who once worked closely with Baldoni, accessed her phone and iCloud data without authorization, leading to the survival of two key claims under California's Penal Code Section 502 and conversion law. Section 502 is no joke. It deals with unauthorized computer access and carries both civil and potential criminal implications, meaning that if the allegations hold, Jones could face serious exposure. The conversion claim adds more weight, tying Jones directly to the alleged harm by asserting that she deprived Abel of control over her personal data. And that kind of control loss, even in the digital world, counts as property interference. But not every claim survived the first round. The judge dismissed some, including the Wiretap Act and Stored Communications Act violations, though importantly, with permission to amend, which means Abel can refile those if she adds enough specific detail about what was taken, when, and how. The key difference here is that the Wiretap Act applies to live interceptions, while the Stored Communications Act covers data already saved to the cloud, so Abel needs to show whether her communications were captured in real time or after the fact. If she can prove that her messages were accessed live through iCloud or another platform, those dismissed claims might make a strong comeback. The judge also pointed out that her invasion of privacy and emotional distress claims lacked personal context. Basically, she needs to show the human side of the harm, how humiliating it felt, what kind of anxiety or sleeplessness she experienced, and how her reputation took a hit. That's how she makes the story more than just a technical violation. It becomes a deeply personal invasion of trust. Then there's the promissory fraud claim, where Abel says she handed over her phone passcodes to Jones only to have her number ported back under a promise that the data would not be misused. To revive that claim, she must spell out exactly who made the promise, when, how she relied on it, and how it hurt her. In short, she needs to connect the dots between a clear promise and intentional deception. But the headline here is that the surviving claims, Section 502 and conversion, are enough to keep this lawsuit alive and moving toward discovery, which is the part of the process where both sides exchange evidence, emails, and messages. That's where cases like this often blow wide open. And according to court filings, Abel now has permission to obtain communications between Jones, Van Zandt, which is Blake and Ryan's company, and other connected figures. If that discovery shows coordination or knowledge of the data's origin, the case could escalate fast because Section 502 doesn't just target the person who accessed the data. It can extend to anyone who knowingly benefits from that access. That means if Van Zandt or Blake's team used or relied on data that was unlawfully obtained, they could potentially face civil liability, and if prosecutors see enough, maybe even criminal exposure. And that brings us to the wildest twist, the Van Zandt subpoena controversy. Abel argues that after her data was accessed, Van Zandt filed a Doe lawsuit in New York and used subpoenas to make stolen data look like it was lawfully obtained, a process she calls data laundering through litigation. If that's true, it's massive, because it means the entire foundation of that lawsuit could be tainted. Subpoenas are supposed to compel only what someone has a legal right to possess. And if the source data came from unauthorized access, then no one ever had that right in the first place. That would make the subpoenas invalid and the entire Doe case a cover-up to disguise the origin of stolen material. The judge's comments suggest he's open to that logic, which means discovery could reveal whether those subpoenas were used to legitimize unlawfully obtained content. If proven, the evidence could be excluded, and sanctions or punitive damages could be on the table for any party found complicit. For Blake and her company, the risk here is that Section 502 allows liability to reach anyone who aids, assists, or benefits from unauthorized access, and if discovery finds that Van Zandt used material it knew or suspected came from Abel's phone, that opens an entirely new legal dimension. The court has already set a timeline for Abel to file her amended complaint by October 31st, and that amendment could include additional detail about the iCloud data, the privacy violations, and the fraudulent promises, and it might even name new defendants like Van Zandt or Blake herself. Her legal team has already taken depositions and obtained emails between Jones and Van Zandt, so the groundwork is there for a more expansive filing. The judge has also made it clear that the surviving claims are properly stated and won't likely be dismissed again, so this case is definitely moving forward. If Abel can prove that the data chain truly ran from her phone to Jones to Van Zandt to Blake's legal filings, that could dismantle the evidentiary base of Blake's own countersuit. The court could strike key pieces of evidence and issue penalties if it finds that anyone knowingly relied on unlawfully sourced information. Even without criminal charges, the reputational damage would be immense, especially in Hollywood where public image is everything. The idea that a celebrity's company might have used data obtained through unauthorized access, even indirectly, would dominate headlines and spark debates about digital privacy and accountability in the entertainment industry. And beyond just this case, the broader implications are huge. If the court rules that data obtained through unauthorized means can't be legitimized by later subpoenas, it could change how celebrity lawsuits and corporate disputes handle digital evidence forever. In the coming weeks, as Abel's team prepares to amend the complaint and discovery continues, the question becomes not just who accessed what, but who knew what and when. Every new email or text uncovered could either confirm or collapse an entire narrative. This isn't just about Blake or Justin anymore. It's about how data, power, and accountability collide in an industry built on image control. The fact that Abel claims she has evidence showing that on the very day her phone was accessed, someone in Blake's circle allegedly mentioned seeing her texts adds an entirely new layer of potential corroboration. If that's proven, it could tie everything together in a way that makes it impossible for Blake's team to deny awareness. So as we wait for October 31st, the tension is sky high. For Abel, this ruling gives her momentum and legitimacy. For Jones, it's a major problem. Section 502 is both civil and criminal, meaning her alleged actions could invite law enforcement attention. For Blake and Van Zandt, it's about containment. Can they distance themselves before discovery reveals too much? Because if this case goes to trial and the data chain is proven, it will not only unravel the lawsuit, but could trigger a reputational crisis that no PR team could spin away. And even though some viewers might be disappointed that the federal wiretap claims were dismissed, it's worth remembering they were dismissed with permission to amend. So if Abel's team strengthens those allegations with more concrete examples, they might still come back. What's undeniable is that the surviving 502 claim keeps this story alive and strong, turning what many assumed would fade quietly into a full-blown legal showdown with massive consequences. This is more than a courtroom drama, it's a test of truth, privacy, and accountability in the digital age, and it's already rewriting the script for how celebrity cases unfold. So what do you think, bestie? Was the Van Zandt subpoena just a procedural misstep or something far more calculated? Did Blake's team know where the data came from, or were they caught in the crossfire of someone else's actions? Drop your thoughts below, hit that like button, and make sure you're subscribed because when this amended complaint drops, the fallout could be enormous. Until then, this is just the calm before the storm, and judging by how much evidence is about to surface, things are about to get very, very real.